Good afternoon. My name is Kate Schenk, and I'm the Deputy Director of Legal Aid Chicago. Welcome to Legal Aid Chicago's fourth session of our series, Finding Solutions, Legal Aid for Our Most Vulnerable Populations. Today's session will focus on how legal aid works with and serves people living with disabilities. So now to get started, I'd like to turn it over to the host of today's session from Kirkland and Ellis, Nader Vulis. Nader?
Thanks very much, Kate. It is my pleasure to welcome everyone to today's installment of the Finding Solutions series. Kirkland and Ellis is really pleased to be a sponsor of this important series, and we are very proud of our long-standing partnership with Legal Aid Chicago. At a personal level, I am especially proud of the fact that more than 300 of my colleagues here in our office have worked at Legal Aid Chicago clinics or on LAC cases. I think the breadth of that commitment really reflects a couple of things. First, a shared belief that nothing any of us do as lawyers is more important than the work we do to support organizations that change people's lives by delivering on the promise of equal justice. And second, maybe more fundamentally, that here in our community, there is no organization that does more or more powerful work to make that a reality than Legal Aid Chicago. So thank you to everyone who's here today for your support of Legal Aid Chicago and for choosing to put your own time and resources behind the mission. Thank you most of all to the staff of LAC for the work that you all put in every day that makes this a stronger and better community for all of us. With that, I'm happy to introduce Steve Scheuer and Sal de Los Angeles from the Public Benefits Practice Group, who will be leading today's session. Over to you.
Thank you, Nader. And as good afternoon, everybody. My name is Sal de Los Angeles. I'm a staff attorney with our Public Benefits Practice Group. And during this presentation, Steve and I will provide an overview of the US population living with a disability. We will also review the different Social Security programs for the disabled, and we'll conclude with a discussion of overpayment issues and our response strategies, such as appeals, waivers, and payment plans. So sending it over to you, Steve.
Great, thanks, Sal. As mentioned, I'm a staff attorney in the Public Benefits Practice Group at Legal Aid Chicago. And in that role, one of my main jobs is to help some of our most vulnerable clients living with a disability gain access to and maintain financial stability through Social Security benefits. But before getting into kind of the nitty-gritty of eligibility for Social Security, I thought it was important to recognize that there are a wide range of perspectives on understanding disability. And for example, the CDC has a very broad medical view describing disability as any condition of body or mind, making it more difficult to do certain activities and interact with the world. I'm looking at a more legal definition from the Americans with Disabilities Act. A disability is defined as a physical or mental impairment substantially limiting one or more major life activities, a person with a history or record of such an impairment, or a person perceived by others with such an impairment. And I think two big takeaways from these definitions for me are that first, it's a functional definition. It's looking at individual circumstances and how a disability impacts a person's life. So there isn't going to be a one-size-fits-all understanding of it. And I think the other point that the definition brings up for me is that understanding disability has to be done within the context of social engagement. So interactions with family, friends, communities, government agencies, legal aid organizations, social institutions, norms, values, expectations, all of these elements shape the understanding of disability. So looking at the numbers a little more closely, In 2019, the US population had over 328 million people. And of that, just over 42 million, or almost 13%, reported living with a disability. And I think that this is a relatively conservative estimate. For example, the CDC in 2018 suggested that 1 in 4 American adults lived with some sort of disability, and that comes to about 61 million people. So it's a very significant number of members in our community. And breaking these numbers down even further, I think it can be helpful to look at how disability intersects with other social factors. So for example, age. In 2019, just under 5% of the population 0 to 18 years old reported living with a disability, whereas amongst folks who are 75 and older, almost 50% reported living with a disability. And then looking at how disability intersects with race and ethnicity, on the surface, there might be less variation than certainly I expected. But I think when other factors are considered, other economic factors, the disparity between different populations becomes much more pronounced. So for example, looking at disability by race and ethnicity and including employment, of the African-American community living with a disability, 25% participates in the workforce, and that's compared to 35% of their white counterparts. And then considering poverty rates and how those intersect with disability and race, the disparity becomes even more pronounced. So amongst the African-American community living with a disability, 37% report experiencing poverty compared to 24% of their white counterparts living with a disability. So to put a few more numbers to this picture, in 2017, 26% of working age people with a disability experienced poverty. And over 60% of households with a member who had a disability reported being asset poor, meaning that they didn't have enough in assets to live at the federal poverty level for 3 months. And then 2/3 of African Americans with a disability reported being unbanked or underbanked, meaning that they had limited or no access to high quality financial services, instead relying on payday loans, currency exchanges that have higher interest rates and fees. And as you can imagine, that's especially harmful when folks are already living off of a very fixed income with Social Security benefits and relying on these institutions for their banking services. So keeping in mind these significant financial challenges that are faced by our clients living with disabilities, I wanted to turn to Social Security's definition of disability, which is a very economic one. So Social Security defines disability as the inability to do substantial gainful activity due to a medically determined physical or mental impairment that's expected to last at least 12 months or result in death. And substantial gainful activity is a term of art that's defined as the maximum amount that a person can earn from work in a month and still be considered disabled. So if a person is able to earn over a certain dollar amount, then Social Security will automatically consider them not eligible for disability. In 2021, that amount is $1,310 for disability and then $2,190 for statutory blindness. So if a person can work and make more than that amount, they will not be found disabled by Social Security. So there's 2 main programs that Social Security offers to try to address the significant financial challenges that we've talked about. The first is Social Security Disability Insurance, or SSDI. And there's no income or asset test as long as a person meets the definition for being disabled. However, it does depend on a person's work history. In order to qualify, a person must have worked enough in the previous 10 years to have insured status when their disability begins, and then their monthly benefit amount or their primary insurance amount is going to be determined by their lifetime history of work and the amount that they've earned. The second program, Supplemental Security Income, or SSI, is for individuals who are determined disabled or blind by the Social Security's definition, or over the age of 65 and low income, low resource. So SSI does have a means test. There are income and asset limits. However, it doesn't depend on a person's work history. So even if someone's never worked at any point in their life, they can still qualify for SSI. There are maximum monthly benefit amounts. In 2021, it's $794 for an individual. It's $1,191 for an eligible couple. So just a sense of the utilization of these programs. In April of this year, just under 13 million people were receiving SSI, SSDI, or a combination of the two benefits for disability. And while 13 million people might seem like a significant number, and it is, it's actually very hard to prove medical eligibility for benefits to Social Security. So in 2018, of all of the disability decisions that were made, only 34.5% were found medically approved at the first level of review. Of those that were denied and appealed to the next level, known as reconsideration, only 10.8% were approved. And of those denied at reconsideration and then appealed to the administrative law judge level, or the appeals council, which is the highest level of administrative review, or into federal court, only 38% of those were found medically approved. So in total, in 2018, less than half of the medical decisions made were approving applicants for disability benefits. Even if a person's able to overcome those significant barriers to establishing disability, they have to continue to approve their disability on an ongoing basis. So depending on a person's medical conditions and how likely Social Security thinks they are to get better, a person will have their eligibility reviewed every year, every 3 years, or every 7 years. And so that's even for conditions where there's a very, very low chance of any improvement. A person will still have to show Social Security that they meet the medical definition of disability at least every 7 years. And then under the law, any child who receives benefits as a minor has to be have their medical eligibility reviewed at the age of 18, applying that adult disability standard that depends on SGA. It's a different standard when a child is put on disability benefits. So as an example of just how difficult it can be to stay on disability benefits, I wanted to talk about Courtney's case. And Courtney had been granted SSI at the age of 5 due to intellectual disability. She received benefits until she turned 18, when Social Security by law did a medical review of her eligibility using the adult standard of SGA. And these cases are especially difficult because when Social Security is making this review of medical eligibility, they're looking at the medical records, the education records, and Courtney's work history. And for a child with no other underlying medical conditions, it's unlikely that she's going to have sought a lot of medical treatment for intellectual disability. So the medical records there's not a whole lot in them. And the education records, while they're strong and they suggest that Courtney required a lot of support in school with an individualized education plan, special education, struggling to meet benchmarks at grade level, Social Security is often reluctant to translate those limitations from an academic setting into a work setting. And then Courtney's only 18. She's never tried working at a job and been able to show that she was unable to do it due to her disability. So given this lack of evidence, Social Security takes the standpoint of, well, let's deny the benefits, let her try working, and longer evidence down the line that she should be put back on benefits. Of course, I mean, this sort of defies common sense because intellectual disability isn't something that's going to magically get better at age 18. So when we stepped in at the administrative law judge level, it was really our job to translate those significant limitations that Courtney faced in the academic setting to the workplace and convince the judge that she would need a level of support at any sort of job in the national economy that the typical employer just wouldn't be able to provide. So as you can imagine, that's a really daunting thing to have to try to convince an administrative law judge just to stay on disabilities benefits for the exact same condition that you had when you were 17 and you're now 18. So I want to shift away from the challenges of establishing medical eligibility and talk a little bit about the income and resource limits for SSI. And I'm focusing on SSI because the rules for this program are especially strict. Social Security, by their own language, calls this a program of last resort. It's meant to be sort of the final stopgap measure for our clients with disabilities who have no other means of financial support. In terms of income, unearned income, so that's like support from family, friends, is subtracted dollar for dollar against that $794 a month maximum benefit. And then half of earned income is subtracted from that $794. So if someone receiving SSI wants to get a little extra help from family or try to maintain a part-time job, they can very quickly see their SSI benefit decrease to zero, essentially keeping them at that $794 maximum. And then in terms of resources, the individual limit is $2,000. If a person has over $2,000, they're eligible for no SSI in any month they have over $2,000. For a couple, it's $3,000. And I think it's worth noting that these dollar amounts have not changed since 1984. So it's been decades since the reality of sort of current economics has been taken into consideration. Social Security has a very expansive understanding of a resource. It's cash, personal property, and real property that an individual owns, can convert to cash if not already cash, and there are no legal restrictions from the individual using that for their support and maintenance. Now, while it's typically understood in terms of the individual's resources, in effect, it oftentimes applies to the whole household. Because if a spouse is receiving SSI, resources owned by the other spouse can be deemed to the one receiving SSI and count against that $2,000 limit. If a child is receiving SSI, the parent's resources can be deemed to the child and count against the $2,000 limit. So oftentimes, the resource limit is something that affects every member of a household. Some specific examples of what counts as a resource, bank accounts, and it's important to note that it's the total value of all the bank accounts that has to be under $2,000. It's not a $2,000 limit for each bank account. Retirement plans can count, even if there'd be a penalty for withdrawing a lump sum from the retirement plan, it can still count as a resource. For cars, one car is exempt, but if the household has any other cars, those can count as a resource. Real property, the primary residence is exempt, but if an SSI recipient's name appears on a deed or a mortgage because they signed for a family member with bad credit, even if they don't consider themselves owning that house or ever plan to live there, that can still count as a resource. So it's important to be really careful what people put their names on, even if they don't consider themselves owners of that resource or able to even use the resource. Life insurance policies can also count against that $2,000. So I'm going to turn it over to Sal to kind of look at how these resource limits play out in the lives of some of our clients.
Thank you, Steve. So in Jeremiah's case, That's one example that required showing that he was resource eligible. Jeremiah is and was on title for 2 properties with significant tax debts and citations. One of them is in fact an empty lot, and the other is an uninhabitable house. But despite these characteristics, as Social Security alleged that they held significant value, believe it or not. With the use of comparative market analysis, or CMAs, we successfully rebutted the value. And despite continuing to be on title for both properties, Social Security agreed that their equitable value were significantly below the $2,000 limit. So nearly a year later, Social Security approved Jeremiah's SSI application with $794 in monthly benefits, plus nearly $11,000 in back pay. So that was a significant victory for Jeremiah. And that's just one of the cases in which resources was an issue at the beginning. So back to you, Steve.
Thanks, Sal. So Anthony came to us after living with chronic health conditions for many years. He had applied for SSI and been medically approved. However, the next step was establishing financial eligibility, and Social Security used one of their data matching systems to search for unreported real property that SSI applicants might own. They got a hit that said Anthony owned a second home several blocks from where he had lived with his family for over 30 years. The name on the deed for that property in the data matching system was exactly the same as Anthony's. Now, Anthony had never owned a home in his life, let alone a second home. He didn't even own a car. So this was clearly an error, but the burden fell on Anthony to convince Social Security that he didn't own this property that was coming back in their data matching system. And as you can imagine, this was incredibly difficult because you're really proving a negative. You don't get documents showing that you don't own a property. So what we had to do was go to the recorder of deeds. We got a copy of the deed, a copy of the mortgage, and we compared Anthony's signature to the signature on the deed and mortgage. They didn't match. We also saw that there was a co-signing spouse on the deed and mortgage, and Anthony had never been married. So we were able to establish that Anthony didn't own this property, but as you can imagine, it was overwhelming to have finally been approved for SSI, a benefit that is designed precisely for the most financially vulnerable, and then be told that you own a second home when you've never owned a first home to begin with. And then another example is Patrice's case. Patrice was a single parent. Her daughter, Ashley, received SSI as a child. Patrice got a federal tax refund of over $5,000, which she immediately put into her bank account to try to increase her financial resiliency, have a cushion for any unexpected costs that might come up. The Social Security has a rule that a federal tax refund doesn't count as a resource for 12 months. But after a year, the full amount that remains in the account counts as a resource. And this is actually the same rule that applies to the stimulus checks that a lot of people have been getting during the pandemic. And remember that with SSI, a parent's resources can be deemed to a child. So Patrice having this money in her bank account created a problem for Ashley. And after the money had been in the account for 12 months, Social Security stopped Ashley's benefits for being over-resourced and gave Patrice the difficult choice of having to either spend down those $5,000 and lose that cushion she'd established, or miss out on getting that $794 a month in regular income. And I think this is a great example of how the strict resource rules of SSI prevent families from accumulating any sort of wealth or cushion to deal with financial hardships, for example, COVID-19. So there's a few ways that we've identified to help our clients overcome this strict $2,000 limit. For example, there's a plan to achieve self-support or a PASS account. This is recognized by Social Security, and it can be used to exempt income and resources that are set aside for the specific purpose of a work goal, so that will allow a person to gain self-sufficiency in the future. There's also Achieving a Better Life Experience, or ABLE account, which is for individuals whose disability began before the age of 26. And then there are special needs and pooled trusts. And all of these options can allow a person to save more than that $2,000, and it won't terminate their eligibility for SSI. But it's important to recognize that there's a lot of rules and limitations on each of these types of accounts. So we'd recommend definitely consulting with Social Security and an attorney, especially in the case of the trusts, before setting up one of these accounts and really understanding what the requirements are. And now we should be about halfway through, and here is the code for CLE credit. And so with that, I'm going to turn it over to Sal to talk about the consequences of going over that resource limit, especially overpayments, and some of the ways that they can be dealt with.
Thank you, Steve. It is worth noting that according to studies, communities of color depend more significantly on benefits from Social Security. They have less access to technology and are more concerned about the financial costs. In 2019, for example, there was a 7 to 12% gap in technology access compared to their non-Hispanic white counterparts. And while the pandemic increased the use of technology across all demographics, access continued to be a concern for communities of color. Now, since the start of the pandemic, individuals have had only 3 ways to connect with Social Security: either through their online portal, by phone, or by fax. And despite the challenges of navigating their website, speaking with someone by phone has been even more challenging due to the limited number of agents answering calls. Due to the limitations in connecting with Social Security, it is an additional challenge and cost for people with disabilities to report their earnings and resources, or other information for that matter. Requests are also more difficult to make because they are not always automatic, such as requests to reconsider, waivers, and even those that would qualify for a streamlined process, as I will explain later. And generally, there's an increased confusion, such as what Steve mentioned earlier, the effect of the economic stimulus payments on SSI benefits, for example, all of which increases the likelihood for Social Security to allege overpaying individuals, which may lead to increased overpayment issues. So let's talk about overpayments. Generally, an overpayment occurs when an amount paid to an individual was more than the amount Social Security should have paid that person. And they generally also result from the failure to impose deductions, suspend, reduce, or even terminate benefits. During the pandemic, some of the common contributors to overpayments include the inability to access the local office in person. For many of our clients, it's also their inability to connect with an agent either by phone, fax, or online. Also, last year, Social Security decided to delay taking adverse actions against individuals during certain months of the pandemic. And finally, there's a belief by some individuals that Social Security is an all-powerful agency with access to all of our records, so reporting is not necessary. Not quite so. At Legal Aid Chicago, some of the most common types of SSDI overpayments we see are related to work over the SGA limit. In other words, countable gross earnings over $1,310 in 2021. Also, it's colloquially referred to as working too much. Workers' compensation awards, including lump sum gains, and statutory benefit continuation, which is the amount of benefit a person received during an unsuccessful appeal. For SSI clients, the most common type of overpayments are due to resource, income, and also statutory benefit continuation. When we review an overpayment case, we start with at least one of two jurisdictional questions. First, is the notice dated within 65 days? If so, the individual may file a timely appeal. If the notice, however, is over 65 days, then the question is whether is there good reason for a late appeal? For example, never having received the notice of overpayment because it was mailed to the wrong address is good cause for a late appeal. Second, if there is no good cause for a late appeal and the SSI notice is within, or the notice in general is within 1 year, individuals may request to reopen their case for any reason. This applies for both SSI and SSDI. However, if the notice is within 2 years for SSI or 4 years for SSDI, individuals may request to reopen their case, but they will require good reason. The decision to reopen a case is discretionary, not by right. So if Social Security decides not to reopen a case, there is nothing else the person can do. This is different from appealing a decision. With an appeal, the person maintains the right to go off the ladder of appeals. With SSDI overpayments allegedly due to working too much or working over the SGA limit, it becomes essentially a numbers game, and we put on our accountant's hat on. The question is whether Social Security get the numbers right. Did Social Security consider all possible deductions? So we review every pay records and timesheets during the alleged overpayment period. We then apply all possible deductions, such as work expenses that are related to one's impairment, pay time off, such as vacations, holidays, etc., and even work subsidies, which is when an employer, for example, pays the individual at the same rate as all other comparable employees, despite the fact that the individual's performance level is at 90%, for example. So the 10% difference is deductible. And then finally, we average the annual earnings if possible. If the monthly amount is less than the SGA limits for the year, the individual has a case against the merits of the overpayment. Now, Michael's case is an excellent example where, despite taking nearly a year of advocacy, we helped resolve the issue. Michael was on SSDI and also worked at his local movie theater. Social Security alleged that due to his work at this movie theater, his disability ended, and because his pay was not terminated on time, he was overpaid over $6,500. We put on our accountant's hat and carefully reviewed his pay records and deducted his transportation costs because due to his intellectual disability, he required special transportation to and from work. And in the end, Social Security reinstated his benefits, eliminated the overpayment, and sent him over $20,000 in back pay. Now, With SSI overpayments allegedly due to resources, the strategy is somewhat similar. The question is whether Social Security considered the correct values and applied all possible exclusions. So we review all bank statements for their balance on the first of each month. And in situations where there's a joint bank account and the individual claims not owning any of the money in the account, we assess whether the ownership can be successfully rebutted. We also review insurance policies for their cash value. Now, with regards to vehicles and or real estate properties, we assess their equitable values. In other words, if there's a car note and that note is deducted, that note can be deducted from the current value of the vehicle to get the equitable value. And then finally, we apply all possible exclusions, such as what Steve already mentioned, a one vehicle, the primary residence of the client, and possible business properties that are used for self-sustenance. These are just to name a few. In Carmen's case, it's an example where the resources do not have to be in the US to be considered a resource for the client. Carmen is an 85-year-old legal permanent resident and on SSI. As it is common with many elderly individuals, she prefers Mexico's sunny weather during the winter months. Considering Chicago's winters, who can blame her, right? So last year, she decided to travel to Mexico right before the pandemic. And although she planned to return within 30 days, she got stuck in Mexico for several months. When she returned, Social Security alleged an overpayment because previously they learned that Carmen stayed at quote unquote her house when she traveled to Mexico. And also because she stayed in Mexico for more than 30 days. The alleged property was a miscommunication, but to prove so, we obtained a certified property titles search result from the Mexican government. In the end, Social Security eliminated the alleged overpayment and reinstated Carmen back on SSI. Another common type of SSI overpayment is due to income. Here, it is all about what the individual receives that is of value, such as income and gifts. So we start with all earned and unearned income. We'll review any work records, but unlike with SGA, everything is considered when they are received. If the person received free rent or food, that is considered because it is worth something, with some exceptions, such as receiving SNAP benefits or also known as food stamps. For minors, the income of their parent is deemed to them, but not the other way around. In other words, the minor's income is not deemable to the parent if the parent is the claimant, the SSI claimant. And then finally, we apply income exclusions, such as the $20 exclusion to the value of the unearned income and $65 disregard from all earned income plus 1/2 of the remaining balance. So the general rule of thumb is that if you are on SSI and have earned income, about 1/2 will count against your monthly SSI amount. If the overpayment cannot be challenged, the next option to consider is a possible waiver. A waiver requires two things. One, to be found not at fault for causing the overpayment, and two, that recovery of the overpayment would defeat the purpose of the act or the law, or be against equity and good conscience, or for SSI, recovery would impede effective or efficient administration of the law because of the amount involved. Don't worry, I will explain in detail these two requirements in the next slides. But an important point here is that waivers stops all recovery or adjustments until Social Security responds to the request to waive the overpayment. So what does fault mean? According to Social Security law, a person is blameless or not at fault when they maintain high degree of care in reporting and in good faith attempted to prevent the overpayment. In other words, you're timely reported to Social Security all of your work records, your bank statements, etc., and tried your best to prevent the overpayment. Now, examples of when good faith does not exist is when you knowingly made an incorrect statement to Social Security, or should have known that the statement was incorrect, or you did not provide Social Security the necessary information to make the correct determination, or you accepted the payment that you either knew or should have known was incorrect. How does one establish that recovery defeats the purpose of the law? Because that is, again, one of the other requirements for a waiver. Well, for SSDI, it requires showing that you need all of your income for ordinary and necessary expenses, such as rent, utilities, food, etc. For SSI, it's similar. You also need to show that you need substantially all current income for ordinary and necessary expenses, which is generally always the case because it is presumed that $794 a month is barely enough to cover necessary expenses, not to mention medical expenses that a lot of individuals on disability incur. But with SSI, you also need to show that you have $3,000 or less in resources, or $5,000 or less if you have a dependent. On the other hand, if you can establish that recovery would be against equity and good conscience, you do not need to establish that it defeats the purpose of the law. However, establishing that recovery is against equity and good conscience requires that because of the notice or actual payment, you either relinquished a valuable right or change your position for the worst, or lived separately from the overpaid person when the overpayment occurred and did not receive any of the money. So basically, one must demonstrate reliance and a decision based on that reliance that would injure you if recovery were to occur. In November last year, Social Security instituted a streamlined waiver request process for some overpayments that occurred during the pandemic. And in theory, this process would only require a phone call to Social Security and should be automatic upon request. But the result is far from, it has been mixed at best, to be honest. Only overpayments that occur between March 1st and September 30th of 2020, because Social Security did not process any actions due to the pandemic, and the overpayment was identified by December 30th of last year, is eligible for this waiver request. All other overpayments require the standard process and proof requirements. And when all fails, in other words, the individual cannot challenge the merits of the overpayment and it is not eligible for a waiver, they may be eligible for a low payment plan. For example, a 36-month payment plan is automatically available upon request. I want to emphasize that, upon request. If you do not request that 36-month payment plan, Social Security will take your entire next paycheck. However, if the individual wants an even lower payment plan, Social Security will review the income and expenses of the person to determine how low can the payment plan be. Unless the person has a 100% Medicare Part D subsidy, they would then be eligible for a $10 repayment plan. Having Medicare Part D subsidy means being enrolled in medical programs such as Medicaid, or in California also known as Medi-Cal, Medicare Extra Help, or in Medicare Savings Program. For those with SSI overpayments and they continue on SSI, Social Security will deduct 10% from their benefits to recover the overpayment. So To finalize this session, here are some important takeaways. 1, report all gross earned income each month, especially if on SSI, because your earnings this month will affect your benefits, your benefit amount in 2 months later. Report any new medical impairments that affect you, as this will help establish potential impairment-related work expenses that could be useful for you later. Report your new address, because this is how Social Security primarily communicates with you. Maintain letters from Social Security because they help explain actions Social Security takes. Maintain your pay records if you're currently employed, including your timesheets in the event that Social Security alleges an overpayment due to SGA. Speaking of SGA, know the SGA level and understand how over that limit affects your benefit. Know about any alleged overpayment. If you're on SSI, by the way, if you do not know what caused the overpayment or what is the overpayment about, you should contact Social Security and request an explanation. Now, if you're on SSI specifically, this is important. Do not add your name on title of properties you do not own. And you can only rebut joint bank accounts. So if your name is on a title of a property, SSA will assume that you own it. And finally, if possible, open an online account with Social Security where you can conveniently do some of the reporting, reviewing your pay history, for example, and other records. And that can maybe help eliminate some of the hurdles in having to contact Social Security by phone and even in person. But the bottom line is, it is already significantly difficult for a lot of individuals on disability to experience all these hurdles. And although these are complicated and complex rules pertaining to Social Security disability benefits, no one should be discouraged to apply. If you are disabled, we encourage you to call Social Security and request an application either for SSI and SSDI. In other words, let them do the work and tell you that you're not eligible. Because if you're eligible, there's a significant financial incentive for you. Now, let me introduce you to Melissa, who will talk about pro bono opportunities. Melissa?
Thank you so much, Sal. And the work that you and Steve are doing along with others at Legal Aid Chicago is so critical for this population and helping them meet their basic needs. And I'm going to bet that many of you are wondering if there's a way to help out by providing services to this population. And for those of you who may be interested in working alongside us, I'm going to highlight some of the ways that you can get involved in Legal Aid Chicago's work. At Legal Aid Chicago, we have over 20 different volunteer opportunities across the agency, and our opportunities run the gamut of skill levels and time commitments. We simply could not do this work without the assistance of volunteers, and last year alone, over 500 volunteers donated over 10,000 hours working alongside us. And we offer a wide variety of opportunities to help serve our clients and meet their basic needs. One of our volunteer projects focuses on helping clients get and keep public benefits. This project helps connect clients, many of whom are people with disabilities, to get and keep benefits such as food stamps, Medicaid insurance, and other types of cash assistance that might be available. This opportunity is appropriate for attorneys and for non-attorneys, and we offer comprehensive training, which is available for you to watch whenever you can. And we also offer support throughout the case. Navigating a complex bureaucracy is very challenging for clients on their own, but with an advocate on their side, it is manageable and clients are much more successful in securing these important benefits. These cases are not long-term, they are not time-intensive, they do not require in-person advocacy, but they are crucial to helping a client get what they need. We could really use your help in meeting the needs of our clients in this project and many others. And you can find more information about all of our volunteer opportunities on our website And you are welcome to reach out to me with any questions that you might have about any of our opportunities and how you might be able to help. And I'll turn it back over to Kate Shank now.
Thank you so much, Melissa. And thank you to Steve and Sal for sharing your expertise and your work with us. So this concludes the planned content portion of today's presentation. In a moment, we'll start the question and answer portion. But before we do, just a quick reminder, we'd appreciate it if you could fill out the brief survey about the presentation. So to do that, or if you'd like CLE credit, please click on the link in the chat and fill out the form. And please note that certificates of attendance will be sent out within the next week or so of attending. We also would love for you to join us next week at our session discussing the needs of survivors of sexual assault. So the panelists are going to remain to answer your questions, which you should please type into the Q&A at the bottom of your screen. And I know that we have questions that have already come in. So Melissa, could you please take us through the Q&A?
My pleasure. So starting out, Steve, you mentioned Courtney, one of our clients, and one of our attendees wants to know, so was Courtney eventually approved for Social Security?
You may be on mute, Steve.
Apologies about that. So Courtney was approved for SSI, and one of the keys was getting a statement from a job training counselor who really highlighted the amount of support that she needed. Because in the record, Social Security saw that she completed high school, she'd done job training, kind of superficially appeared ready to enter the workforce. But in talking with the job counselor, she needed help completing all of the forms. Directions had to be explained multiple times. There was a high level of support that just wouldn't be available in an employment setting. And once that was put in front of the judge, it changed the outcome.
Wonderful. And this is a question asking if the 794 monthly SSI benefit is uniform across areas that have different costs of living.
It is. And that's something that our clients really struggle with, is that not only is it uniform across geographic area, but it doesn't really take into account the actual expense that our current financial environment requires. It's oftentimes coupled with food assistance, subsidized housing, other programs, because the 794 just isn't enough on its own.
And this is a question, Steve, again for you, about, you mentioned special needs trusts. And so the question is, if a family gift counts as unearned income, how is income from a special needs trust treated as exempt?
So the special needs trust is a vehicle recognized by Social Security as exempt. And so the resource, so the balance in a special needs trust is exempt as a resource. If a family gift is just given as, say, cash to a family member with a disability, then it's considered unearned income that counts as both income and a resource. I'm not sure if that question was referring to specifically income generated by the money in the trust, but that's something that's complicated and would probably be beyond the scope of what I could answer right now. But that's why speaking to an attorney about that is a good idea, because there's a lot of limitations on how the money within the special needs trust can be used. Depending on the source of the money in the trust, there can be a payback provision so that the state Medicaid agency gets reimbursed for the cost of the medical assistance provided during the person's lifetime after they've passed away. So it's not a perfect or easy to use vehicle for saving money.
Thank you, Steve. It sounds like you know a lot about it, Matt.
It's a very complicated and necessarily complicated process, and that's why getting an attorney involved is almost necessary.
Great. And both you and Sal talked about appeals, and so there's a couple questions about Are benefits generally continued pending an appeal? I know, Sal, you mentioned specifically waiver, but can you both talk about when a benefits might continue pending an appeal and when they might not?
So a waiver may, benefits may continue. There's a person can request statutory benefit continuation. However, there are some requirements, and that particular type of continuation is only available when the allegation by Social Security is that the person is no longer disabled or there because there's been some medical improvements, for example. If it's because the person was deemed over the resource limit or over the income limit, then it is generally they're not eligible for statutory benefit continuation. And the other requirement is that they have to request that timely within 10 days after receiving the notice. So if Social Security says that your medical condition has improved, we urge you to call the office immediately and file an appeal if you believe that that determination is incorrect. And at the same time, request that your benefits be continued.
Thank you so much. And what about if you're approved for SSI, can your benefits be retroactive?
Yes, so there's a protected month, which is the month when you initially inform Social Security of your intent to apply. It doesn't mean that you have to submit the application immediately then, but you inform them in writing or that you intend to apply for the benefit. And so it usually takes a few months before you become eligible. And so those months, during that month, you will accrue a certain amount of your monthly benefits. At the end of when you become eligible, Social Security will then assess how much were you eligible since the month, your protected month, which is when you inform Social Security of your intent to apply. And based on that amount, they'll add it up, and at the end, you'll get what's called back pay. And that's how we've been able to get a significant amount of back pay for some of our clients.
Great. And one question that's come up is sort of the timeline, both for receiving a decision on an initial application from Social Security, as well as the timeline to resolve an appeal. Can either of you talk about those timelines?
Sure. So it can take quite a while to get a decision on an initial application. It really there's a lot of moving pieces. So it really depends on how the state agency that reviews medical eligibility, how long it takes them to get all of the medical records, how complicated the case is, and then the decision made by the state agency gets sent to the local Social Security office that then has to process the state's decision. So it can take months to get an answer on an initial application. The key is that on any decision that's issued, there's a 65-day appeal window. So it's 60 days technically from the date that a person receives the notice, and Social Security assumes you get the notice 5 days after the date on the notice. So you can add 65 to the date on the notice, and your appeal has to be submitted by then. Following that appeal, it can take months up to years for it to work through the appeal process. Social Security has had some backlogs, especially at the administrative law judge level, that have meant that people have waited a year, 2 years to actually get their appeal heard. And then it typically takes at least 2 to 3 months to get a decision from an administrative law judge if it's at that level. So it's a long process.
And if I may add, Steve, part of that reason too is because there are the multiple layers of appeals that are involved. The first step upon receiving that decision that you disagree with is you request Social Security to reconsider that decision. And they may agree to reconsider it or not agree to reconsider it. If they don't agree to reconsider it, then you need to request, if you still disagree with that decision, you need to request a hearing before an administrative law judge. That's the next step. If at that point it's an unsuccessful appeal, you can continue to appeal all the way as far up as the appeals council. And now we're talking about months and months and months in time. So it is an arduous and lengthy process, but it is a process that once you start, we strongly encourage you that to continue with that process, until the end.
And I should say that that's for medical. If you're appealing a medical decision, if you're appealing a financial decision. So, for example, if Social Security said you went over that resource limit and you get SSI, at the reconsideration level, you can request an informal conference, which is kind of a meeting before Social Security makes a decision on your appeal, where you can present your arguments, give them any new evidence. And that's something that should be scheduled within 15 business days of submitting your request for the appeal. So it really kind of depends on the issue that you're appealing, that there can be much quicker timelines that Social Security is supposed to follow.
Great. And one other question that's coming in is about, are there any exceptions for small cash gifts that people receive, or something like a charitable gift? I mean, how can people still receive something to sustain them despite the asset and income limits?
So that there is, for unearned income, there's a $20 exclusion, which is not very much. And again, that has not been increased since the Social Security program began. So, that's not really a great amount. And it's really hard with cash gifts. Those almost always count as unearned income. However, if family members are paying vendors directly, so buying items from the store directly, or paying utility bills directly, that can avoid being counted as income or a resource. The only exception to that is housing and food. If family members help pay for your housing, so help cover your rent, or help pay for your food each month, that will count as income. They call it in-kind support and maintenance. So we oftentimes advise people on SSI who want to get some financial help from family to try to have that help go towards payment of stores or vendors for items that the family needs or that the person needs.
And Steve, you mentioned this just now. In addition, sort of, have you heard of any proposed rules or efforts to try to get the Social Security Administration to increase that asset limit amount? And has there been any debate about why they wouldn't do so?
My understanding is that there have been a number of attempts to get bills passed that would increase that. I'm not up to speed on the exact status of those. But I know that it's something that a lot of advocates in the Social Security community think definitely needs to be changed, for sure.
Great. And we've got a couple of questions about sort of how things are working. And Sal, you mentioned this in particular about how you can access the Social Security office. Now, can you talk about how an appeal is being conducted at this time? Are they in person? Are they telephonic? Or what's going on? And what do you think will happen in the next few months? Right
now, all appeals are being handled telephonically. You certainly have the right to request your hearing to be held in person. But when you do that, the hearing date is there aren't any being scheduled right now. So your hearing will be scheduled at some point in the future. And right now, we don't know when that will be. The only circumstance in which that would be beneficial, financially beneficial for a client, is that if a client is in current pay. In other words, they're receiving benefits, and so it wouldn't financially hurt them to delay their hearing until an in-person appointment is available. But right now, all of the hearings are being done telephonically. In some cases, they are allowing video conferencing hearings. So they're using Teams as a way of interacting with the judge or seeing the judge over the phone, over a computer. But a lot of our clients struggle with that because first, their lack of access to these technologies is a problem. but also their understanding of how to work. Even some professionals, sometimes myself, struggle with teams. And so it's not just because the pandemic increased our access, or maybe even just allowed us to explore more of these technologies, doesn't automatically mean that we're now experts in the use of them. And so it's a struggle that I think Social Security is continuing to see, and we certainly are seeing it with our clients. So those are basically the ways in which hearings are being conducted right now.
Great, thank you so much. And you both alluded to this. Can you just talk a little bit about how receipt of a stimulus check would affect someone with who's receiving Social Security benefits, whether that be SSI or SSDI? I think it's a source of confusion for people.
Sure. So for SSDI, it shouldn't have an impact on those benefits. For SSI, it shouldn't have an impact as income or a resource for 12 months. After 12 months, any amount of that check, that's the stimulus check, that's still in a bank account or still being held by the individual, would count as a resource.
You gotta buy those things to stimulate the economy, huh, Steve?
Right, exactly.
Get out there and stimulate. We've got a question here about whether Legal Aid Chicago still has a veterans benefits project, and specifically it's asking about the interplay between VA disability and being eligible or not eligible for SSI benefits. And unless Steve or Sal wants to weigh in, I would say we do have a Veterans Right Project, and that is absolutely something that the Veterans Right Project can assist with. And so we encourage people to connect with us either directly by calling our intake line at 312-341-1070 or by connecting with us through the Illinois Armed Forces Legal Aid Network. So Illinois AFLAN is another resource for individuals. Anything else?
Add to that, that with SSI, because it is viewed by Social Security as that program of last resort, there's a requirement that in order to be eligible for SSI, you have to apply for any other benefits that you might be able to get. So oftentimes, if someone's applying for SSI, they'll have an obligation to apply for VA benefits if it's possible that they could be eligible for benefits.
Great. And one question that's come in is a couple of specific questions about, when someone might be eligible for something, but in particular, you went over the work, what limits you can make for income on SSI, and there's a question sort of saying, can you just go over those again very, very quickly so that people can make note of those?
So for SSI, there's generally, for earned income, there's a $65. So whatever you earn, let's assume you earn $1,000. The first thing is you will deduct $65, and then you will deduct any impairment related work expenses that you incur. If you are working, but you're required to take Uber or the taxi, to get to work and to come home because of your intellectual disability, as was in the case, as is one of my clients' case, for example, then you may be permitted to deduct all of those expenses before Social Security will then count half of the remaining balance. But generally, if you do not incur any impairment related work expenses, the math is $1,000, you deduct $65, and then half of the remaining balance is counted dollar per dollar against your Social Security SSI benefits.
Great. And Steve, you sort of started a little bit at the beginning of the presentation talking about the percentages of people who are denied benefits. Is there any breakdown of, by disability, what kind of denials are made? In particular, this question is asking about, are there percentages about how many people with mental health disabilities are denied Social Security benefits?
There may be, to be honest, the statistics that I was looking at for that did not list that. All it really broke it down by was whether a person, it sort of broke it down by the procedural reason for the denial or the allowance of benefits. It didn't go into specific medical conditions. So I'm not aware of that, but it may very well be out there.
Great. Okay, sort of just a follow-up on that last question, and then we'll wrap up in the interest of time. You mentioned, Steve, can you just reiterate, if a person is eligible for VA benefits, does that mean the individual is no longer eligible for SSI or SSDI? And it was just a little bit a clarification on what you just said.
No, it doesn't. A person can get both. It's really just if you are getting SSI, Social Security will oftentimes send you a letter saying you need to apply for these other benefits, including VA benefits that you may be eligible for. The same thing with a pension. If you're getting a pension from a previous employer or something, that can impact both your SSI and your SSDI. So really the recommendation is if you receive any other benefits or think you might be eligible for any other benefits, it's best to report that to Social Security because they can help you figure out what you might need to apply for or what you're ultimately eligible for.
Wonderful. All right, I'm going to turn it back over to Kate Schenk to close us up.
Great. Thank you so much, Melissa, for walking us through the Q&A. Thank you so much to everyone for being here and for all of your terrific questions and your attention. Really appreciate Steve and Sal and the time that you've spent with us today. Thank you for joining us. We'll hope to see you next week, Wednesday at noon for our 5th session. Thanks, everyone.